Welcome Inside the Law. This is where, in case you're new here, we take you inside the real justice system, the way it really is in real life, not the way that it's presented to you if you just watch TV or the movies, but the way that it really is. And sometimes we see the good and the bad, and we also see the ugly. Just the other day, we saw a lawyer being told he was going to have to spend the Father's Day weekend in jail. Why? Because he had the nerve to call out a judge who had committed an ethics violation. It's called having an ex parte discussion with a party. Ex parte meaning a private, secret, if you will, one-sided discussion without all the necessary parties being there. And when he called the judge out for meeting with the prosecutor and her witness behind closed doors and allegedly, as we are told, perhaps browbeating the witness into making sure that he testified the way apparently the prosecutor wanted him to testify, the judge threatened to cart him off to jail if this lawyer did not disclose how he found out about the secret meeting.
Mr. Williams does not wish to go forward without me being here. You are removing me against his will, my will. You're taking away his right to counsel. And you're conducting material parts of this trial without me present, and I can't learn about it by watching online. So for that reason, additionally, I asked for a mistrial. And I assume you deny, but I'd like you to deny our motions for mistrial. You denied the other people.
I've denied your motion, but I'll certainly take that under advisement, sir.
Actually, right after that, the prosecutor reminded the judge that, look, it might be best to have this lawyer, in the courtroom while he's conducting the trial. Otherwise, you deny the defendant his right to counsel. Then, of course, later in the day, the cavalry arrives and the strike force from the Georgia Association of Criminal Defense Lawyers showed up, led by its president, Ashley Merchant, and attorney Alex Susor. And there were dozens and dozens of other members of the strike force and the GACDL task force that were there in support of Brian Steele, because he did nothing wrong other than being an advocate for his client. After a brief hearing of sorts, I'm using the term very loosely, it wasn't much of a hearing, but the judge changed his mind a little bit and ordered Brian Steele to spend the next, 10 weekends in jail for a total of, 20 days for criminal contempt. And then we found out yesterday that the Georgia Supreme Court, of course, has granted him a supersedious bond, an appeal bond. And Judge Glanville, by the way, was so adamant, there's no bond, there's no supersedious, none of this. He's wrong. He was wrong then, and he's wrong now. And I said it at the time. The reason it got to the Supreme Court is they filed it with the Court of Appeals, and the Court of Appeals said, well, we think maybe because one of the defendants has a murder charge somewhere in this underlying indictment, since murder cases automatically bypass the Court of Appeals in Georgia, they go straight to the Supreme Court when they go on appeal. So the Court of Appeals transferred the case, the emergency motion for bond, to the Georgia Supreme Court, and the Georgia Supreme Court wasn't entirely sure that that was correct either. the appellate jurisdiction for this contempt, but what the Supreme Court did do that was very practical, because of course the Supreme Court does have the power over all of this appeal. They said, look, we know that a lawyer is basically getting ready to go to jail by the end of the week. So we can't waste time figuring out jurisdiction. We know that we have it here at the Supreme Court. So the Supreme Court said, transfer everything here. We're going to take the appeal. We're going to issue a writ of certiorari, basically, to basically bring the contempt appeal up to the Supreme Court. And they unanimously granted a bond, the supersedious, that Judge Glanville was so certain would not be granted. And he said, you don't even qualify for it. But of course, the Supreme Court within 48 hours had done just that, as I predicted right here. And so did many others. And so now Brian Steele, of course, will not have to spend Father's Day in the bug-infested Fulton County Jail. And for that, I think most of us can be thankful. Yesterday, we saw something in this case where there was a motion to recuse Judge Glanville for various things. Attention, I want you to watch this from yesterday, and then we're going to explore in detail what a motion to recuse looks like in Georgia, what this specific motion to recuse looks like, and we're going to decide if the judge was right or if he was wrong.
And you filed a motion to recuse me. You filed an affidavit consistent with that, pursuant to Uniform Superior Court Rule, I believe 25.2. The court's had an opportunity to read your motion. I've also had an opportunity to take a look at, because this issue comes up a fair bit, Baptiste versus the state. I invite you to take a look at that, and that's from our Court of Appeals, 229 Georgia Appeals 691. Basically, you can't file a motion to recuse for ruling that a trial judge makes, okay? And that's what you're doing in this particular situation. You're saying you don't like what I ruled upon. You're alleging some facts in an affidavit that support that decision. Because if that were the case, then no trial judge would be able to sit through a trial and give adverse rulings. So for the reasons set forth in Baptiste and other cases, I'm going to deny your motion to recuse on its face, okay?
Your Honor, may I just address what you said? I disagree with your characterization that I filed a motion as a result of any ruling.
No. Well, you did in your affidavit. I'm taking in your affidavit as face value, okay? All right?
Yes.
I'm not contesting where you got the information from, at least not yet.
Yes.
But I'm just saying that because it also encompasses that I made a ruling. And as a result of that, if I make a ruling and you don't like it, then every litigant will say, I want to recuse you, Judge Smith or Judge Glanville or Judge whoever, okay? So part and parcel of it is that's why I'm making my ruling in this particular case. Remember, bias. I've got to do something extrajudicial, and you're in your particular, like I would have to say something about you or your clients or anything like that, which I would never do because I'm a steward of this particular process. So I understand what your objection is, or what your statement is in terms of your motion to recuse, and I'm going to deny it.
And I believe, Your Honor, that under Rule 25.3, that you have to cease acting right now.
No, I don't.
And that you can, if I can just finish, and then I promise, if I can just finish this. I believe you have to cease acting. I believe that under 25.3, you have to look at the timeliness of the motion, and you have to look at the sufficiency of the affidavit. I do not believe that you are permitted to just simply deny without taking those steps.
Is that it?
Yes, it is, Your Honor.
Okay. All right. So noted.
Are you denying at this point?
I'm still denying your motion, okay?
Would you grant a certificate of immediate review?
No, sir.
Because
No, sir.
if you grant that certificate, you were
It-
always talking about how the appellate court.
No, because if I grant the certificate, it stops the case, okay?
I don't agree with
And I'm not going to do
I
that.
don't believe it stops the case.
I'm not going to do that.
And if you would
You can appeal it at the end of the case. If I'm wrong, I'm wrong. Hey, I'll live by it.
But
Okay?
aren't you interested in removing the cloud that's hanging over the case right now, Your Honor? If you grant
Sir, I'd be real careful about what you're pleading at this point in time, what you're stating to the court. As a matter of professional responsibility, remember, we haven't nugged out all of the issues involved in that affidavit. And I would be very careful if I were you, because you have some professional responsibility obligations individually and to this court. And so, I would just leave it at that respectfully. I don't want to get into an argument with you about that, but I would just tell you that, tread lightly, okay, in terms of that at this point.
I understand, Your Honor, and I believe that the certificate of immediate review would be in the interest of the court.
I'm not going to do that.
Would you make factual findings regarding?
I am not at this point in time going to, I've denied the motion, okay?
I believe that's an error, Your Honor.
All right. Okay. Thank you, sir.
Thank you.
Now he's worried about professional responsibility, ethics, and all sorts of things like that. So what I'm going to do is show you the rules that apply to recusals of judge in the state of Georgia. Okay, the duty of a trial judge, and I'm pulling this right from the rules of Superior Court and the canons of judicial conduct. When a judge is presented with a motion to recuse or disqualify, accompanied by an affidavit, the judge shall, it doesn't say may, it says shall temporarily cease to act upon the merits of the matter and shall immediately determine the timeliness of the motion and the legal sufficiency of the affidavit and make a determination. assuming any of the facts alleged in the affidavit are to be true. So you see, the judge has to basically look at the prima facie claims that are made on the face of the affidavit, and assuming they are true, the judge is not to weigh on whether or not they are true. He's got to assume they are true. And if so, the facts stated in the allegation are true, whether a recusal would be warranted. And if it is found that the motion is timely and the affidavit is sufficient, the recusal would be authorized if some of the facts of the affidavit are true. Another judge shall be assigned to hear the motion. Shall be. The allegations of the motion shall stand denied automatically. What that means is that for the time being, it's not granted. The other judge has to rule on it, right? The trial judge shall not otherwise oppose the motion. I mean, did you see Judge Glanville? He was opposing this motion. In reviewing the motion, the judge shall be guided by the canons 3 of the Code of Judicial Conduct. Well, I happen to have the relevant part of that for you. This is what the judge has to consider. Judges shall disqualify themselves in any proceeding in which their impartiality might reasonably be questioned. So you heard the judge say something about it's got to be something extrajudicial, which means outside the courtroom. No, it doesn't. It doesn't. It's right there. If his impartiality can reasonably be questioned. I don't know about you folks, but I think you can make a pretty damn good argument with a straight face that based on what we have seen in this courtroom, in this trial, his impartiality can be questioned. I question it. Do you question it? Tell me in the comments if you question it and why. I got lots of reasons, but the most recent reason is you can't go and have a private, secret conversation in your office with the prosecutor and her witness without telling the defense and without including them. You can't do it. For all the reasons that we've talked about in streams earlier this week, go back and check those out if you missed them. I explain in great detail how ex parte communications with one party, not including all of them, are wrong. They are unethical. They are not allowed. They are, as my guest said the other day, they're like a very bad word. If you're caught having an ex parte conversation, doesn't fall within any of the very limited excuses, you can lose your job as a judge. The Georgia Judicial Qualifications Commission takes this very seriously. Judges have lost their jobs for much less.